This check, check.
Lost students, those who are volunteers, have nothing to do right now, settle down. Including discipline volunteers, except Manu and Israel, everybody settle down. Amruta, settle down. Arif, settle down. Students who are coming now, come to the front.
Before we start, general instruction to the participants: switch off your mobile phones or keep them on silent mode, and no sleeping in the OD. A very warm good afternoon. Participants and audience, kindly rise as the dignitaries have arrived. Kindly be seated. A very warm good afternoon to one and all present here. It is with great pride and excitement that we welcome you all to the final rounds of the Kjcl Moot Court Competition 2025. Before we move on to the final rounds, a video depicting the facts proposition will be played now.
In 2018, amidst the fast-paced offices of NMX Company Private Limited, Nikita Kumar and Arjun Mehta found solace in each other. What began as friendship soon evolved into a love that felt destined. By December 2020, they were married. Nikita stepped into the Mehta family home, a place that was supposed to be her sanctuary, but beneath the surface, challenges began to form on both sides. Nikita had always been driven by ambition. She was a corporate professional, but in 2022, she made a bold decision to leave her well-paying job and pursue a dream she had long nurtured: content creation. Her decision was met with mixed reaction. On one hand, Nikita's followers grew in number, but on the other hand, the Mehta family struggled to understand her shift. Arjun, her husband, was caught between supporting his wife's dreams and the expectations of his family. The Mehta family had always been more traditional, and they expected Nikita to conform to the lifestyle they valued. By 2024, Nikita had reached the peak of her career, winning the most prestigious Metropolitan Popular Choice Bloggers Award. But all anyone could ask was, where was Arjun? That night, one mistake became a scandal, a viral video, and a family that fell disgraced. And then Nikita disappeared from the spotlight. Meanwhile, Shri, Nikita's cousin, traveled from Australia to surprise her, expecting joy, but instead finding her in distress. As they talked, the mood shifted. Nikita suddenly began coughing and gasping for air, and then gasping, coughing, desperate whispers. Arjun, mistake, unhappiness, sorry. Before the silence took over, a family in mourning, a brother in rage, a confrontation that turns violent. The Mehta residence erupts in chaos. Naveen Kumar, her brother, demanded answers. Accusations flew. The confrontation turned violent, leaving Praful Mehta seriously injured and Arjun and Arush with minor wounds. Naveen and 5 others were arrested for assault, but later released on bail. As the dust settled, the past emerged. Naveen Kumar revealed that Nikita's in-laws disapproved of her quitting her well-paying job for content creation. Her mother-in-law demanded gold, claiming she hadn't brought enough during marriage, and the family pressured her to claim her ancestral property from her father. He alleged that Nikita's death was a case of dowry harassment, deepening the sorrow of her loved ones. Nikita's mother tearfully recounted how her in-laws restricted her visits, denied her the joy of holding her newborn niece, and even refused to let her see her injured mother, all in a calculated attempt to seize her property share. Nikita's in-laws defended that they denied her visit because her father-in-law was undergoing angioplasty and the situation at home was tense. After Nikita's death, a pre-scheduled video was uploaded on her social media.
I will end up in such a situation. There was a reason where I was not putting videos for the past few months because
Nikita's voice fills the room. her last confession, shocking her followers. In it, she revealed that she quit content creation for a marriage. She admitted that her in-laws disapproved of her career and spoke about a recent disagreement with Arjun over their behavior. She also made an emotional plea for understanding and forgiveness, speaking about the emotional toll she had endured. As the video went viral, it triggered public outrage, with many mourning the mental and emotional abuse Nikita endured, allegedly driven by dowry demands from her in-laws. But while the world mourned, Arjun's family had a different perspective. They believed they had done everything possible to support Nikita when she married into their family. Arjun's parents, particularly his mother, defended their actions by saying that the demands for dowry were exaggerated. In an attempt to defend himself, Arjun insisted that Nikita's death was a result of depression over a failed career deal, not the culmination of years of family tension. But as the investigation continued, shocking revelations surfaced. Nikita's post-mortem confirmed she had died from aluminum phosphide poisoning, a pesticide used in the Mehta family's food storage business. This raised suspicions of foul play. The truth, however, remained obscured, and the case grew murkier when another woman, Ruhi Mehta, Arjun's first wife, came forward. She revealed that she had suffered similar mental torment during her marriage to Arjun and his family.
When I first married Arjun, I thought we would be building a life together. But soon, his family started creating problems over the smallest things. I was unable to handle this constant distress, so I filed for a divorce.
Even suggesting that Arjun had married Nikita before finalizing his divorce with her. Nikita's parents filed a complaint against her in-laws, leading to an FIR under sections 101, 80 and 86 of Aryavarta Nyaya Sanhita. The police arrested Arjun and his parents. Arjun denied the dowry allegations, claiming Nikita died by suicide due to depression after losing a fashion brand deal. The trial court ruled that Nikita's dying declaration lacked clarity and that the prosecution failed to prove harassment, making Section 118 of Aryavarta Sakshya Adhinayam 2023 inapplicable. The pre-scheduled video was also dismissed as evidence, leading to the acquittal of all accused due to insufficient proof of dowry demands. Nikita's parents appealed to the High Court of Vindhya, but the court upheld the acquittal, stating that dowry laws could not apply to an invalid marriage. The court dismissed Nikita's final words, rejecting her last message, declared her marriage invalid. Now, the state has appealed to the Supreme Court of Aryavarta, where the final verdict awaits. On one side, there were those who believed Nikita had been the victim of a cruel and manipulative system that forced her to choose between love and self. On the other hand, there were those who saw Arjun and his family as victims of a woman who had tragically fallen prey to her own dreams and pressures, causing chaos in her marriage and family. Both sides had their truths, their pain, and their perspective on the events that had led to a young woman's untimely death. A promising love story turned into reality darker than the filters on social media. Love became duty, admiration turned into expectation, and soon the whispers of happiness faded into silence.
Now I request both the teams selected for the final rounds to come on stage and be seated on the respective sides. I request the honorable judges to be seated on the dais. We're deeply honored to have with us an esteemed panel of judges whose vast legal expertise and keen judgment will shape the course of today's competition. I would now like to request Sanjana, student of 10th semester BA LLB, to introduce to the judges to the gathering.
I, Sanjana Selvaraj, student, 10th MBA LLB, deem it a privilege to introduce the judges to the gathering. Today, we have amongst us Honorable Justice C.T. Ravikumar Sir, Honorable Justice S.R. Banurmat Sir, Honorable Justice Dr. Prabhakar Shastri Sir. Honorable C.T. Ravikumar Sir hails from Kerala. Sir graduated in zoology from Bishop Moore College, Mavelikara, and obtained his LLB degree from Government Law College, Calicut. Sir enrolled as an advocate in 1986 and began practice at Mavelikara Courts before moving to the Kerala High Court. He also served as a government pleader from 1996 to 2001, senior government pleader in 2006, and later as a special government pleader. Sir was also appointed as the additional judge of Kerala High Court in 2009 and was made a permanent judge in 2010. He also served as a president of the Kerala Judicial Academy and executive chairman of Kerala State Legal Service Authority. Sir was elevated to the Honorable Supreme Court of India in 2021. We are indeed honored to have you amongst us today, sir. We welcome you. Justice S.R. Banurmat Sir graduated in 1968 and studied law in Belgium. Sir began his independent practice in 1979, specializing in criminal and constitutional law in the Karnataka High Court and appearing regularly before the Supreme Court. Sir also served as additional state public prosecutor from 1990 to 1994 and state public prosecutor from 1994 to 1997 for Karnataka. Sir was elevated as a judge of Karnataka High Court in 1997 and delivered numerous landmark judgments across various branches of law. As the designated judge for monitoring the mental health and founding president of Bangalore Mediation Center, Sir was invited by the US Justice Department. Sir became the Chief Justice of Kerala High Court in 2009. We are honored to have you too, sir. We welcome you. Honorable Justice Prabhakar Shastri Sir hails from Davangere and holds a law degree from RL Law College, Davangere. Sir obtained his MA and LLM from Bangalore University and PhD from the National Law School of India University. Sir enrolled as an advocate in 1991 and practiced in various courts across Bangalore and beyond, also serving as standing counsel for undefended accused in the Sessions Court of Bangalore Rural District. Sir was also appointed as a district and session judge in 2002, served in Kalburgi, Bengaluru, Bagalkot, Chikbalapura, and Tumkur, besides a brief tenure as a registrar in Supreme Court of India. Sir became an additional judge of Karnataka High Court in 2017 and a permanent judge in 2018. We welcome you too, sir. Thank you.
Thank you, sir, for gracing us with your presence and for taking the time to guide these young legal minds today. With that, we now commence the final rounds of the KJCL Moot Court Competition 2025. The court is now in session.
Counsel seeks permission to address the benches, Your Honours. Much obliged, Your Honour. Counsel, on behalf of the petitioner, humbly seeks permission to address the jurisdiction in the present matter. Much obliged. Counsel, on behalf of the petitioner, approaches the Honourable Court under the below provision, Article 136 of the Constitution of Aryavarta. The Supreme Court may, in its discretion, grant special leave to appeal from any judgment, decree, determination, sentence, or order in any cause or matter passed or made by any court or tribunal in the territory of India. Counsel seeks permission to proceed with the facts, Your Honour. Much obliged, Your Honour.
Facts already, which was shown, whether you want to say, repeat it.
Apologies, Your Honour.
Unless you want to say or give any stress to any particular point. What I'm saying is, normally a lawyer should open the argument by narrating the facts.
Yes, Your Honor.
It is a video was played. So if you want to give stress to any particular point, particular facts, say it.
Yes, Your Honor. In the present...
If you want to present it, you can. Normally
Your-
that should be the way, but that is the usual way. But this kind of a thing, which was already video, it was played, that is why we said. But anyway, it is up to you to, in your own way you can.
Yes, Your Honor. The counsel would proceed with the statement of facts if seeks permission. Much obliged, Your Honor. In the present matter, the facts certain to a married couple who is Nikita Kumar and Arjun Mehta in the year in December 2022, despite a already existing marriage of Arjun Mehta, which was not dissolved with Ruhi. In 2024, Nikita got intoxicated, which eventually led to a decline in her social media activity, Your Honor. Her cousin, Nikita's cousin, witnessed her death due to aluminum phosphide poisoning, which was stated in the post-mortem report. Further, a pre-scheduled video was released after the death of Nikita in the present matter, which stated constant disagreements between the marriage, between Nikita and her in-laws and the husband in the present matter, Your Honor. Furthering the allegations of harassment and cruelty caused due to the distress of the deceased in the present matter, an FIR was filed by the family of the deceased in the present matter, and the trial court acquitted the accused and stated that the dying declaration and the pre-scheduled video.
The FIR was lodged. Which are the sections under which the offences alleged?
Apologies, Your Honor. Under provisions
Which are the
for
offences alleged?
Section 80 of BNS, Your Honor, for dowry death. Section 85 for cruelty, read with Section 86, which defines cruelty. And Section 108 for abetment to suicide, Your Honor, as our prayer states.
We put that question because it has relevance.
Apologies, Your Honor.
It has relevance, that point.
Yes, Your Honor.
What are the sections?
Yes, Your Honor.
The commission of which the offences are alleged against that person, it has some relevance as
Yes,
far
Your
as the facts of the case is concerned.
Yes, Your Honor. We approach this court under Section 80, 85, and 108 of BNS, Your Honor. Counsel submits that the trial court had acquitted the accused in the present matter and also declared that the dying declaration and the pre-scheduled video must not be admissible in the court. It was upheld by the High Court and stated that invalid marriage does not come under the purview of dowry laws. Thus, counsel has appealed under SLP to this court for dowry-related matters, Your Honor.
Counsel, you did not tell us for whom you are appearing.
I am appearing in, the counsel is appearing on behalf of the state for the deceased, Your Honor.
That you should open.
Yes,
I
Your
don't
Honor.
know whether you are defense or...
Yes, Your Honor.
Okay, go ahead.
Counsel seeks permission to approach with the issues, Your Honor. Much obliged. As counsel 1, I would be dealing with issue 1 and 2, and my co-counsel would be dealing with issue 3. The issue 1 surrounds around whether the term marriage must be interpreted broadly to include de facto relationships and informal unions, specifically in matters of dowry harassment. Counsel would like to submit that the term marriage should be interpreted broadly to include such kind of relationships in cases involving dowry harassment, which is one of the most pervasive social evils that the country has been striving for the combat years, Your Honor.
You used the expression invalid marriage.
Yes, Your Honor.
Whether it is an invalid marriage and why it is invalid?
Yes, Your Honor, the present
There cannot be
case-
an invalid marriage. Are you actually using the expression invalid for void?
Yes, Your Honor, invalid marriage as in it does not fulfill the conditions of Section 5
That is
of...
why again we are saying, is it invalid or void?
What is the difference between void and invalid?
Your Honor, Section 11 of Hindu Marriage Act states it void ab initio is a marriage where a living spouse exists and you get
You
married.
use the expression void.
So
Yes,
it is
Your
void
Honor.
marriage.
Yes, apologies, Your Honor. It's a void marriage. That is what the counsel for the petitioner is claiming. As the counsel states that Article 21 serves as a cornerstone to protect rights inherent to the right to life and liberty. Denying the inclusion of dowry harassment cases in de facto or informal unions from the ambit of legal protection would result in violation of fundamental rights, as it undermines the very essence of right to liberty. The Supreme Court has emphasized that Article 21 encompasses a wide range of...
There also one thing, you use the expression reunion.
Yes.
This is a long living relationship or a simple union.
Your Honor, in this country, de facto relationships as such are said to be live-in relationships. Informal unions, on the other hand, are not defined. We may assume informal unions are any form of unions which is not a marriage. It is a relationship where two people or two individuals come together to celebrate their love or as such. So informal unions, the term has not been defined, but it has a wide range under it, which also includes invalid or live-in relationships, Your Honor. Counsel further submits that the very aspect to which life is experienced is protected under Article 21, and this would include the faculties of thinking and feeling. If a woman is subjected to dowry harassment, whether within a formal marriage or not, she experiences both mental and physical trauma, Your Honor, thereby violating her fundamental rights to autonomy. Because in the present matter, if we state that there must not be protection to the woman or the deceased only because she was not in a formal marriage, would violate her right under Article 21.
Don't think that we are interrupting you, but one thing,
Yes, Your Honor.
it might have skipped your attention one thing.
Yes.
In the proposition about promotion, it said, by December 2020, their love story culminated in a beautiful wedding ceremony on the 15th.
Yes, Your Honor.
So going by the case, despite the fact that the boy was married, this Mehta was married,
Yes, Your Honor.
their second marriage was solemnized.
Yes, Your Honor.
That is the case of the...
Yes, Your Honor. Even though, as per what you stated, Your Honor, Section 7 of Hindu Marriage Act states that if there are ceremonies conducted between two individuals, it would be a valid marriage. But on the other hand, Section 11 also states, and it is a very a point to be noticed if a marriage is to be said valid or not, because any individual performing an act of bigamy or marrying another person when there's a living spouse existing would amount to void ab initio. So irrelevant if a ceremony is conducted or not, in the eyes of law, the said marriage would not be validated for protection of for the present matter, Your Honor. Counsel further submits that Supreme Court has repeatedly held that
Are you supported by any judgment of this court on invalid marriage?
Yes, Your Honor.
In the invalid marriage,
Yes, Your Honor.
that can be alleged.
Yes, Your Honor. In the case of Reema Agarwal versus Anupam and other, if Your Honor could look at page 15 of the memo, para 26, in a landmark judgment, the Supreme Court has stated that the term husband should be construed to include anyone who gets married with a woman and causes cruelty or harassment or coercion to such a woman under Section 80 and 85 of ANS, Your Honor, regardless of the legitimacy of the marriage. This very court has stated that the principle behind this is to look at the intent of why these laws were made. So, if looked at the Dowry Prohibition Act, the very intent of the act is to make sure that all women who go through harassment due to demand of dowry must be protected. Thus, applying the mischief rule of interpretation as held by Hayden's case, the remedy, why the remedy was given while the enactment of the act must be looked at. In the present matter, while Dowry Prohibition Act was enacted, Your Honor, the remedy which was given was imprisonment and fines under the Act under Section 3 and 4, and this remedy was given to protect all women of harassment.
Did you conduct any survey on the authorities on this particular issue?
Apologies, Your Honor.
Did you conduct any survey on the authorities on this particular point?
Authorities as in, Your
The
Honor?
first decision, that is 1929 Privy Council, you will get it.
Apologies, Your Honor. Rima Agarwal is a case of Supreme Court 2002, Your Honor. Counsel further submits that as
No,
stated...
counsel, do you mean to say that a girl and a boy stays together for 1 month in relationship? Can she claim thereafter, I was staying but I was harassed?
Your
Can she
Honor,
cruelty or dowry death?
Your Honor, if a period of 1 month or a period of 7 years or any sort of years, if a woman has been harassed, she must be protected, is what we are contending.
That's a
No,
different
there is
thing.
no objection. But you are bringing it under dowry death or dowry harassment,
Yes, Your Honor.
cruelty.
Yes, Your Honor.
Then where is the stopping?
Your Honor, the term marriage must be broadened further so that even if a woman in a period of 1 month, as stated by you, goes through harassment, must be protected for the reason that the relationship could seem like all well and good, all song and dance
There
in
is
the...
a difference between, rather a notion of difference between these two. Harassing a lady and harassing, the other one is domestic violence. So here there is a difference. So that subtle difference you must be knowing.
Yes, Your Honor. I would like to state that there is an inconsistency which at present matter is present in the Domestic Violence Act as well as the Dowry Prohibition Act. While the dowry, the definition of dowry itself states that marriage is supposed to be an essential for a dowry law, Domestic Violence Act states in section 3, which states that domestic violence, what a domestic violence is. The second clause of this very section states that any form of demand of dowry done or harassment or cruelty caused to any woman would be protected. So under
Not
domestic...
any woman.
Not any woman.
In domestic relationship, yes, Your Honor. As in the case of D. Veluswamy, it has been established that domestic relationship includes relationship in the nature of marriage. So any relationship which is in the nature of marriage, for instance, a live-in relationship, would be protected under Domestic Violence Act, Your Honor. So Domestic Violence Act is giving protection to an individual in live-in relationship, even regarding dowry. But on the other hand, if looked at the definition of the dowry in Dowry Prohibition Act, it states that it's only restricted to marriage.
So if your contention is accepted, it will tantamount to admitting or recognizing and giving legality to bigamous marriage.
Apologies,
Bigamy.
Your Honor, for...
Bigamy.
Yes.
Because what is the the case? Case is that in 2018, knowing fully that a spouse is, living spouse is there for that particular man, you loved and then conducted this marriage.
Yes, Your Honor. The point about bigamy here is that if a person gets into a relation and conduct bigamy, will they be protected or not? If I'm not mistaken, that is...
You said then, knowing fully, thereafter, a marriage was solemnized between you and the other person.
Yes,
That is
Your
why we said.
Yes, Your Honor. In the present matter, it is acknowledged that even though the deceased was aware of a pre-existing marriage with the Arjun in the present matter, even then, counsel would submit that human nature is such that feelings do arise for someone. The counsel is not stating that a crime can be committed for a feeling towards a person, but it is stating that even though there was bigamy committed in the present matter, there was also harassment and cruelty which eventually caused her death, Your Honor. Death is something that must be looked at, and bigamy is also something that must be looked at, but all the cruelty and harassment that was caused by the respondents in the present matter is led to her cause of death, Your Honor. That
You must be understanding one thing. You opened the argument saying that it is under 136.
Yes, Your Honor.
And again, it is again concurrent findings.
Yes, Your Honor.
And therefore, what is the concurrent finding? Is to the effect that there was only a void marriage, there is no valid marriage. Therefore, the provisions of the DV Act would not apply.
Yes, Your Honor.
So you will have to say why it should apply.
Yes, Your Honor, the council submits that even though the law states that dowry laws are restrictive to a marriage and a valid marriage, the council would submit that the mischief rule of interpretation states where a word or a
Counsel,
sentence.
what my lord want to say
Yes, Your Honor.
is that if you see, when there are concurrent findings of two courts,
Yes, Your Honor.
why should we interfere? Supreme Court, why should it interfere? Simple question.
Your Honor, because should women be protected or not in the country is a.
No, there is concurrent finding
Yeah.
already now. District Court has given finding, High Court has given finding. Why should we interfere with the finding of facts? That's the question.
You are actually deviating from your point. You said a woman should be protected. What is this particular act? Is it there for simple protection of women as a whole?
No, Your Honor, I was stating in relation with.
Whenever death of a lady occurs, can you say that it's a dowry death?
No, Your Honor, it must fulfill.
So, how and what is the ingredient necessary to bring it under the definition of dowry death?
Yes, Your Honor, even though it is acknowledged by the council that Section 80 states that within 7 years of marriage.
7 years of marriage, you said.
Yes, Your Honor.
So there must be a marriage.
Yes, Your
And
Honor.
marriage should be a
Yes,
legal,
Your Honor.
valid marriage, a legal marriage.
Yes, Your Honor. For that very reason, the council have come to the apex court to come to a decision whether in invalid marriage shall dowry laws apply or not. Because if this is not protected, the scenario in the society would and as in the present fact.
Have you challenged the section as discriminatory or invalid?
No, Your
There is
Honor.
no definition. Have you challenged it? Validity of the act, section.
No, Your Honor, but we are
The
submitting.
very
in a
purpose and intent of that particular act is there in the act itself, in the opening part of that act.
Yes, Your Honor.
What is the purpose?
The
Have you gone
purpose.
through that?
Yeah, the purpose is to protect a person from cruelty and harassment.
Just go through it.
Council,
Don't guess and say, please go through it. What is the purpose?
the purpose is to protect a woman in the marriage from dowry prohibition.
Woman in marriage.
Yes, Your Honor, yes. Even though it is acknowledged that that is what it is mentioned in the laws and the Dowry Prohibition Act, the council states that if it's not considered to create an inclusive interpretation and include de facto and informal unions or invalid marriages, then it would be demoralizing women in the society, Your Honor. Even though the law states that.
See, you are saying largely, saying that a woman as a whole, they should be protected. There are other enactments for that. Here the question is, this enactment was enacted with a particular purpose. So in order to be within the purview of that act, to bring it under that, and to say that an offense has been committed, the ingredients to attract that particular offense are to be satisfied.
Yes, Your Honor.
Is it not one of the ingredients is that there should be a valid marriage?
Yes, Your Honor.
And the death must have occurred within a period of 7 years since the solemnization of the marriage.
Yes, Your Honor.
Where is the marriage?
Your Honor, before answering that, could I please seek an extension of 5 minutes if that's possible? Yes. Much obliged, Your Honor. Council submits that.
We will have to give some more time because how many times we interfered with this? Every now and then you are understand one thing, we are interfering because you
Yes.
must be knowing when you are presenting a case of this nature,
Yes, Your Honor.
how to present it. We really wanted to say that also and to make you understand. That is why we are putting all these questions.
Yes, Your Honor.
Not for the purpose of harassing or
No,
putting
Your
you in
Honor.
trouble,
No, Your
but
Honor.
you should be knowing it. How?
Yes, Your Honor.
Yes.
Yes. So, apologies, Your Honor. Could you please repeat your question? You
We
would-
said it very simply. If your case is this, there is a dowry death.
Yes, Your Honor.
Despite that fact, the courts below, the trial court and the high court, the trial court acquitted, and that was confirmed by the high court.
Yes, Your Honor.
You are here under 136.
Yes.
Therefore, the question is, if the finding of the courts below, which were entered concurrently, is to the effect that the provisions of to attract, the ingredients to attract a dowry death is not satisfied, or rather the prosecution or the case had failed to establish that. If that is it, and if that is the view, no, there must be prima facie something to
Yes, Your Honor.
interfere with by the Supreme Court.
Yes,
If
Your
that is
Honor.
not there, where is the question of granting leave under 136?
Yes, Your Honor, in the present matter, to prove that there was cruelty and harassment, regarding the marriage, the council would be dealing with, but to prove that there was cruelty and harassment on the woman,
That is the first impediment. You will have to cross that hurdle.
yes, Your Honor. Yes, Your Honor.
Unless you are able to establish that the evidence which were brought legally to establish that there was a valid marriage, there was a marriage, this is not a void marriage, that fact was that evidence was overlooked by the High Court, as well as the trial court and the High Court. Then only there is some scope for interference.
Yes, Your Honor, but the trial court did not, the evidences which were presented by the council as the dying declaration and the pre-scheduled video were not admissible by the trial court, and hence there could not be a conclusive judgment which could be passed in the present matter, Your Honor. To prove that there is cruelty or harassment, my co-counsel would be dealing with how the evidences, if admitted before this honorable court, would lead to cruelty and harassment, Your Honor. Dealing with...
The verdict of the trial court, right?
Your
You
Honor.
did not prefer any appeal.
Yes, Your Honor. The council has approached this bench under 136, Your Honor, because, and not as an appeal, Your Honor, because 136 states that if there is a grave injustice to states, as in it must be a jurisdiction which must be applied in a certain case, because if there is a grave injustice which has been occurred. If I may, Your Honor, cite a Supreme Court judgment, Dalbir Kaur versus State of Punjab, which said Supreme Court principle, which said principles governing criminal appeal by special leave. It said that court may interfere if the conclusions of the High Court are manifestly perverse and based on no evidence. In the present matter, Your Honor, the trial court had not admitted the evidence that the council was trying to prove that there is a matter of...
That is true, Miss Counsel. That particular judgment what you refer to applies to that particular party which has challenged the judgment before the lower appellate court and then has approached the High Court.
Yes, Your Honor.
You have directly come to the Supreme Court without going to High Court by yourself. It is Nikita's parents who went there.
Apologies, Your Honor, the facts state...
In the meanwhile, Counsel, you can answer.
Yes, Your Honor.
See, on one hand, you have put the dowry death
Yes, Your
cruelty
Honor.
case.
Yes, Your Honor.
And how this murder case you have booked?
Your Honor, the
See,
council...
you may not have got what actually my learned brother was asking. Going by what the facts available on record,
Yes, Your Honor.
the trial court after the trial acquitted
Yes, Your Honor.
acquitted the accused,
Yes.
and thereafter the state did not appeal, take up the matter in appeal. Only the parents of Nikita, they filed the appeal. That is why the learned brother asked you the question. Now here only the state. You could have filed an appeal. You prefer not to file an appeal. But Nikita's parents, they unsuccessfully filed an appeal.
Yes, Your Honor.
But they accepted the verdict. They are not before the Supreme Court.
Your
Why
Honor,
should they, a non-appealing party, the state should be permitted to pursue the appeal is the question.
Your Honor, because the present matter is not only restricted to the facts of the case, but also whether invalid marriages must be considered for dowry laws or not, which would eventually give and pass a judgment for the petitioners in this matter or the deceased and provide a justice for her as well. This is a matter.
That's why we asked, have you challenged the virus of the section? You're not.
No, Your Honor, but we are trying to put forward that the term marriage must be construed in a broader sense to include such relationships. The Act as Dowry Prohibition Act is itself.
Now you can continue for another 1 minute in your own way.
Much obliged, Your Honor.
We will not be interfering with you hereafter. Proceed.
Counsel submits that in the present matter, there has also, apart from should the marriage term be interpreted further or should invalid marriage be included in dowry laws, there is also an issue of ancestral property, if ancestral property amounts to dowry or not. Counsel would submit a Supreme Court case where it says Baldev Singh versus State of Maharashtra, where they state that firstly, the counsel would submit that the definition of dowry itself states any property. Any property which is claimed as dowry would amount to dowry, and thus ancestral property is also dowry. Under Section 14 of Hindu Marriage Act, it states that ancestral property is an absolute right of a woman, Your Honor, and thus, if asked in the form of dowry, would be a demand of dowry, and thus the deceased in this matter must be protected for that.
Counsel, what is the evidence of dowry harassment?
Your Honor, my co-counsel would be dealing with that issue. Even then, I would like to state that the dying declaration...
No, facts I'm asking.
Yes, Your Honor.
On facts, what is the evidence?
Your Honor, the in-laws of the deceased and the husband of the deceased tried to restrict her movement out of the house while her mother, the mother of the deceased, had
Nobody says restricted movements.
Your Honor.
Only they were not pleased with her behavior in that party or something, that's all. They expressed their so on.
Your Honor, she also stated in her pre-scheduled video that she had constant disagreements in her marriage as well.
No. Again, that video is acceptable, admissible?
That would be proved by my co-counsel.
No, first thing, what a lawyer should do while presenting a case is, go through the facts thoroughly. You got a case that Nikita's mother got a terrible fall.
Yes, Your Honor.
Even then, she really wanted to go and see the mother who got injured. Despite such a situation, the in-laws did not permit it.
Yes, Your Honor.
So that it's also one of your contentions.
Yes, Your Honor.
That was one of your case, virtually the case which you actually intended to prove before the court.
Yes, Your Honor.
Even in such a situation, that amount to cruelty.
Yes, Your Honor.
Because when the mother fell down and got sustained injuries, she really wanted to go and see the mother. And the in-laws did not permit.
Yes, Your Honor. There are 3 such situations present in our current facts, Your Honor. One, that she was restricted to visit her family even
that
during
exactly
festivals.
Was the question.
Does it amount to cruelty? Straight away question.
Your Honor, it leads to harassment and eventually...
Supposing a lady, married lady, goes to the party, gets drunk, and it is family prestige is affected. Can they not say that be careful, be at home, don't attend such things? Can you not say?
Yes, Your Honor.
Then is it a cruelty?
Counsel submits that not only that, Your Honor, but also the evidence.
Right. Another one is that somebody broke the leg and she did not visit.
Yes, Your Honor.
Whatever, she may be having her own reasons. Possibly, and the reason is her father was not well.
Your Honor, if we state that she was suggested to stay at home because of because she got intoxicated and the reputation of the family had gone down, if that is the reason for her to stay at home, then if the motherly bond that she has and if she is restricted...
You have said, according to you, there are certain instances which could be said to be very cruel.
Yes, Your Honor.
One such circumstance, of course, this one. When her own mother fell down and sustained injuries,
yes, Your Honor,
she was not permitted to go and see.
Yes, Your Honor.
One of the circumstances. Then another circumstance, you have said that a newborn baby You really wanted to have the child on your lap. That was also not permitted.
Yes, sir.
Second thing, then the third one was, there was a consistent demand for bringing the ancestor property. These were the,
Yes,
if we
sir.
correctly understood, this is the case.
Yes, Your Honor. As well as ancestral property, there was persistent demand of gold. Her in-laws and Arjun had stated that she
Anyway, we will take it that. Let us see.
Whose
Yes,
evidence
sir.
is that? Demand of property, ancestral property, whose evidence?
Apologies, Your Honor.
Who has given the evidence regarding demand of ancestral property? Her
Your-
brother.
Yes, Your Honor. It was
Is
conveyed.
Is it substantiated by or corroborated by the evidence of the mother?
Yes, Your Honor, in the present.
No, mother
Your
doesn't say that about.
mother states that, Your Honor, there must be a line of the facts which is created here.
Demand of ancestral property is only uncorroborated version of the brother. Mother does not support it, or nor there is any evidence on that.
Your Honor, it was conveyed to the brother by her, Your Honor. It is the deceased had conveyed to her brother that there was demand of dowry persistently, including gold and a share.
Now conclude your argument.
Yes, Your Honor. Thus, the counsel for the petitioners submit before this bench that the term marriage must be expanded to include de facto and informal unions to protect women from such cruelty or harassment matters as in the present matter. Counsel also submits that considering the cruelty and harassment in the present matter which was caused by the respondents, they must be the demand for dowry and harassment after not succumbing to the wishes of the in-laws clearly amounted to dowry death in the present matter. Counsel thus submits that the issue 1 and issue 2 must be looked at that way. Much obliged, Your Honor. My co-counsel will deal with issue 3.
Please.
The council seeks the permission to address the bench collectively as your honors and individually as your honor. Much obliged. As counsel 2, on behalf of petitioner, I will be addressing the third issue, which focuses on the admissibility of the dying declaration and pre-scheduled video as evidence in the court of law. The council will present this issue in two-fold structure. Firstly, whether the trial court should have given greater weightage to the dying declaration, and secondly, did the trial court err in rejecting the pre-scheduled video as evidence in court of law? The counsel for the petitioner humbly submits that the trial court should have given greater weightage to the dying declaration made by the deceased, considering the surrounding circumstances of the case, Your Honor. The counsel states that the dying declaration is a statement made by a person who is close to his death concerning the cause or circumstance of his death. It is admissible under section 26A of ASA 2023. It is based on the maxim nemo mortuis praesmatur mentor. That is, a dead man will not lie. The court treats a dying declaration with caution and carefully examines all the relevant circumstances before deciding its credibility or honor. Furthermore, section 26A of ASA 2023 does not provide statutory guidelines for recording or evaluating the dying declaration, Your Honor.
To whom the declaration was made?
It was made to Shri, Your Honor, the cousin sister of the deceased.
As per the definition of dying declaration, when it should have been made?
Your Honors, it is preferably made to the magistrate or a doctor or...
Even extrajudicial,
Yeah, it's valid if it is given to a relative also, but it should not be a caused or a converse statement, Your Honor.
That's right. Does any statement given to her friend indicate that it is dying declaration?
Yes, Your Honor, the four words...
What are the words used and what is conveyed? That's all. What is conveyed by her to her friend?
Your Honor, the four words stated...
Incoherent words. It doesn't make sense to indicate that it is a dying declaration.
Your Honor, Arjun directly names the deceased husband, suggesting his involvement in the case, Your Honor. and then the mistake would imply either a regret over the past actions or an acknowledgement of a wrongful act done against her in the past. Unhappiness suggests emotional distress, possibly due to mistreatment by the accused, and sorry would indicate
No,
remorse.
you are on the point of dying declaration we are asking.
Yes, Your
Dying
Honor.
declaration, you are insisting upon dying declaration mainly.
Yes, Your Honor.
What is the dying declaration here? For whom? One is Shri.
Yes, Your Honor.
Another you want to rely upon that video. Correct?
Yes, Your Honor. The
Correct.
video should be admissible as an evidence, Your
Video
Honor.
we'll consider later.
Yes, Your Honor.
Statement before her friend. How does it amount to dying declaration? Does she say anything about she is dying, expecting death? Person tells just before the death or earlier. Not remote sense of time. And even if it is nearby, immediately let us assume she died. Does it amount to any wordings she has stated to dying declaration?
Your Honor, to state this argument, the council would like to go to the case of Paniben versus State of Gujarat, in which there were 10 guidelines stated to find the admissibility of a dying declaration. Your Honor, the words stated by the deceased were spontaneous and were made voluntarily, as Shri, the witness of the dying declaration, will never think bad for a sister and would not have any ill intention to cause the statement or converse the statement, Your Honors. She was staying in Australia, which proves she was visiting India to meet her cousin, so no question of conversing or statement arises, Your Honor.
No, we are not disbelieving Shri's statement.
Yes, Your Honor.
The utterances, we are again particularly on dying declaration. What are the words said? Arjun, mistake, unhappiness, sorry. Does it in any way indicate it's a dying declaration as per section 26?
Your Honor, the word Arjun, which is stated in the dying declaration, is a...
Her husband's name.
But it shows the involvement in the case, Your Honor.
Is there any coherence in the entire sentence or even if it is taken as a whole?
Your Honor, the words unhappiness...
Cause of death. Any indication, unhappiness in they normally complain, woman to friend, I'm unhappy in my house. Does it amount to dying declaration?
Your Honor, the surrounding circumstances would lead to the dying declaration, as the unhappiness would suggest the emotional distress, possibly due to the mistreatment of the accused, Your Honor.
Surrounding circumstances we can't take for dying declaration. There must be proper evidence.
Your Honor, it can be supported by the circumstantial evidences as well, Your Honor.
No. Dying declaration can't be supported by it. There must be specific statement of the dying person that this is the cause of my death. Indicative at least, not in the exact words, but there must be indicative. Nothing is that.
Your Honor, the word mistake and unhappiness are leading to it because she was facing harassment and
Can you say that every couple, merely because they are continuously living as husband and wife, does it mean that they are happy, very, very happy?
Pardon, Your Honor, would you please repeat the
See,
question?
after the marriage, for about 20 years, the marital relation, it continues. Does it mean that they are very, very happy?
Your Honor, but there were instances of...
Unhappiness may be there.
Yes.
Because persons from two different families, they are actually bonded by this, that is this marriage. So definitely born and brought up in different situations, there is bound to be difference of opinion. So when there is a difference of opinion, unhappiness may also be there. What is the nature of the unhappiness? Nothing is said. Simply said that they were unhappy. That is why we say, can you find even a couple where they say that no, hitherto in our life, always we were very, very happy. If somebody says like that, we will have to say that they are actually unscrupulously telling untruth. Because difference of opinion and unhappy situations must arise in life, but then compromise. That is why the life is going on.
Your Honors, but the unhappiness.
So
would-
here, how you will connect these words?
Yes.
Mistake, Arjun, mistake, unhappiness. If we are in the absence of any cogent evidence, conclusive evidence, even this dying declaration cannot be said to be a conclusive proof. That by it's a feeble one. How you will correlate everything?
Your Honors, the dying declaration can be supported by the
How
corroborative.
this can be? That exactly was our question. How you say that this would amount to a dying declaration?
First thing is how these utterances before that Shri amounts to dying declaration. Second, what is the corroboration for that?
Your Honors, the word unhappiness would also suggest the cruelty and the harassment she was facing. In this case, we are presenting the matter in front of the court for the
Understand one thing. Suppose if the wife wanted to go abroad, the husband is not taking her, she may become unhappy. See, she wanted to see a particular film. He said, no, I will not take you. She wanted to go to a particular restaurant. He may say no. Unhappy. So the situation is how you said that she is expecting death, immediate death. To make it a dying declaration, she must be expecting that. These
While
things,
expecting death, some utterances must be made to connect it with
that
death.
person.
That's all.
That is nothing is there.
Nothing in that.
These 4 words, whether they are sufficient.
Your Honor, but the demand of dowry in this case would suggest the unhappiness because.
So you are now coming to the next one.
Yes, Your
Let's come to the next
So
one.
there is no dying declaration according to you?
No, Your Honors, it is a dying declaration in
We
this.
are not satisfied yet. What is the second? All right. Your video, come back to video. What is the dying declaration there?
Your Honors, the pre-scheduled video would not be as a dying declaration, but it would be admissible as a evidence in the court of law, Your Honors.
Has it been
As-
proved? How it to be proved?
Your Honors,
Video recording, how to be proved?
yes, Your Honors. Your Honors, the counsel for the petitioners submits that the pre-scheduled video is a crucial piece of evidence that must be admitted as it directly relates to the deceased state of mind and the circumstances leading to a tragic demise.
We are doubtful about the voice itself. There is no evidence to that it is her voice. Anybody can pretend nowadays. Even your AI chat GPT, you can make voice.
Your Honor, but it was a pre-scheduled video posted on her own social media account, which was set.
Even is it indicative of dying declaration? All right, we will accept it for a moment.
Your
Is it
Honors, we are
indicative
not.
of dying declaration?
Your Honors, we are not stating that the pre-scheduled video is a dying declaration. We
So
are.
it goes out. It will. You want to put it as a evidence.
Yes, Your Honors.
Then there is no dying declaration at all.
Your Honors, the 4.
So that point goes. All right, all right. Proceed.
Please continue, continue.
proceed.
Just merely because we are putting questions, don't be.
Much
Proceed,
obliged, Your Honor.
proceed.
You are arguing well. See, with this kind of questions we are putting, you are answering that. Go ahead with that.
Much obliged, Your Honors. Your Honor, the counsel states that under Section 12 of ASA 2023, fact shows that a person's state of mind, such as distress, intention, or ill will, are relevant when such state is in issue. The video clearly reflects the deceased's mental distress caused by the strained relationship with her in-laws, husband, who repeatedly disapproved of her career change. This disapproval, coupled with their controlling behavior and emotional isolation, Your Honors, significantly contributing to her suffering, Your Honors. Further, the deceased statement in the video revealed that her in-laws continuously reminded her that leaving her corporate job was a mistake, Your Honors. This psychological pressure is highly relevant in the case of dowry harassment, where emotional abuse and coercion plays a central role. The video serves as a strong circumstantial evidence.
Understand one thing also. Under what circumstances you videographed it?
Pardon, Your Honor?
Whether in a normal family life, every day, you will videograph the entire things.
Pardon, Your Honor, I didn't.
Under what circumstances the affairs in a house, this thing, why you videographed it?
Your Honors, the statement of the deceased was.
And who did it?
Your Honors, the
Nothing
deceased.
is there. Who is the videographer? Nothing is there. Under what circumstances it was done? It's also a pre-video. Is it not so? At that time, what was the harassment she was facing?
Your Honors, the deceased was a social media influencer, as mentioned in the facts, and she has herself uploaded the video on her social media account, Your Honors. And she pre-scheduled it, and it went into the, it came into the, onto the social media account after her death, Your Honor.
Yes.
Your Honor, further, additionally, Honorable Apex Court has held that when primary facts
Counsel.
are. Yes, Your Honor.
How did it appear on video, social media after her death? Somebody else must have put it.
Your Honor, it was a it was a pre-scheduled video, Your Honor.
Can it be done?
Yes, Your Honor. It can be done on social media accounts. We can pre-schedule a video.
In advance.
Yes, Your Honor. We can pre-schedule a video on a social media account, and then it can be uploaded at a time when we want it to be uploaded.
Right.
Additionally, the Honorable Apex Court has held when primary facts are not directly established, courts must rely on the inferences from the circumstantial evidences. The pre-scheduled video is one such piece of evidence, proving a direct glimpse into the deceased's suffering. It was a desperate attempt to make her struggles known when she had no other support, Your Honors. The pre-scheduled video supports that it was her last option to show the world how she was facing distress, how the in-laws were controlling her in the family, and how she was facing the cruelty and harassment in the family, Your Honors. Your Honors,
nothing about cruelty. Her disappointment in life. There is nothing about cruelty. You are repeatedly saying cruelty. There is nothing about cruelty in the video also.
Your Honors, but it is mentioned in the facts that she was not allowed to visit her family in the festivals. When festivals were there, she was not allowed to She was not allowed to visit her mother when she broke her leg. All these evidences support that it was a case of cruelty, Your Honors.
Yes, now go move to the next point.
Okay, good.
Yes, Your Honors. Your Honors, the Council would conclude the issues, stating that the petitioner asserts that excluding this video would result in a grave miscarriage of justice, as it highlights not only her mental state, but also the actions and behavior of the accused that led to the distress, Your Honors. Considering its relevance, the Council respectfully submits that the video must be admitted as evidence for a fair and a reasonable judgment, Your Honors.
So you are kind of appreciating the evidences like this. If it is not accepted, it will lead to injustice. See the question, how it is to be decided? The admissibility has to be looked into?
Yes, Your Honors. Your Honors, the video, pre-scheduled video...
If it is admissible in evidence, then only we need to go into the next question, what is the evidentiary value?
Yes, Your Honors.
If it is not at all, if it is inadmissible in law, where is the question of appreciating it and going to consider the evidentiary value?
Yes, Your Honors,
Counsel, continuing that.
Yes, Your Honor.
How video to be proved? Talk on social media, whatever it is. How it should be proved in the court?
Your Honor, the video stated her state of mind, the deceased state of mind.
How it should be proved? Simple question I am asking.
Your Honor, as an electronic evidence in the court of law, in the Supreme Court. Under Section 63 of ASA 2023, Your Honors.
How it should be proved? We know the provisions. How it should be proved? You tell us.
As a circumstantial evidence, Your Honor.
Whatever you are relying upon that video.
Your Honor, because the video states the state of mind of the deceased. When she is conveying the video, she is stating her state of mind.
Counsel, again I am saying, why we should accept it or admit it as admissible evidence. Otherwise, unless you prove it, how you have to prove it? Simple question I am repeatedly asking.
If the bench permits, the counsel would take 1 minute.
All right.
Am I audible?
Yes, Your Honor.
With the permission of the chair, I try to clear myself in this moot court. Certain set of facts, what has been given as the moot court problem, they have to be taken as undisputed facts to some extent. When it says that a video was uploaded and it was exhibited, it has to be taken that it has complied with the legal formalities of proof of the video.
Yes, Your Honor.
Yes. When it says that a demand for share in ancestral property was made, the evidence was the brother and mother of the deceased. And the moot problem shows that their evidence remained undisturbed. If you read it.
Yes,
So, making certain presumptions with respect to facts as undisputed facts as found out by the trial court and high court, we have to proceed further. It is keeping that in light, you can frame your answer and submit to the court.
Then it will be against them because both the courts are concurrently held.
It is not undisputed. It is not the question
is
of undisputed, not
Then
proven
it will go
facts.
against you.
The court can only take note of and appreciate the proven facts. If they were proven facts, the judgment would have been different. The trial court found that the prosecution failed to prove. That was given conformance by the High Court. That is why we put out all those questions, how you proved it. So the question is, when you are coming to the Supreme Court, saying that, especially under 136, what should be there to grant leave? Perversity should be there in appreciation of evidence. What is perversity? If there is total absence of any evidence, still, if the court take that there is evidence, you can say there is a perversity. If an evidence is taken as admissible, or if it was not taken into consideration against the total weight of evidence, weight of that documents, then also you can say, what is that? That is what we were putting all these questions to find it out that. Because normally, 136 is not there cannot be an automatic
Yes,
grant of leave.
Yes. Yes,
You must say, what is the perversity or what is the law, substantial law which is involved in the matter. Merely because you said that if this is not done, there will be injustice. Can that be a ground for in a 136 petition?
Your Honors, the pre-scheduled video we are talking about in this case, we are stating it as a circumstantial evidence which would be added with the dying declaration of the deceased.
That is why at that point of time, she was never expecting any death.
Counsel, if your circumstantial evidence you are relying upon, what is how it should be admitted, considered? Chain of events, there must be a link for appreciating circumstantial evidence. Isn't it?
Yes, sir.
That's the law. Each 1, 2, 3, 4, these are the circumstances. They link to each other. That leads to the conclusion, the guilt or not guilt.
Unerringly point to the guilt of that person and that person alone.
What are the circumstances you have proved? Nothing.
Yes, now you will have to conclude.
All
Please.
right. Good.
Because
With the permission of the bench.
we have actually interfered with you. We will give 2 minutes for you to conclude. Please.
Yes, Your Honor. Much obliged, Your Honors. Your Honor, the counsel would conclude that the petitioner asserts that excluding this video would result in a grave miscarriage of justice because as taken as a circumstantial evidence to support the dying declaration in this case, it highlights not only her mental state but also the actions and behavior of the accused that led to her distress, Your Honors. Considering its relevance, the counsel respectfully submits that the video must be admitted as evidence for a fair and reasoned judgment and the dying declaration should be accepted in the court of law, Your Honors. If the bench permits, the counsel would further move to the prayer, Your Honors.
1 minute, please.
You have not stated any law on this aspect. You are supposed to speak on law.
which are all the offenses for which the accused are charged with?
Your Honor, cruelty, dowry, and murder in FIR report.
Yes.
Yes.
So section 101, what is your submission?
Your
you are
Honor-
concentrating only on section 80 BNS.
Your Honor,
Section 101, you have that, right? If you are unable to satisfy the court on 80, you can switch over to 101,
yes, Your Honor.
but you are totally silent on that.
Your Honor, the council is proving this matter by the use of section 108, Your Honor, which states abetment to suicide. These all instances, when we focus on cruelty harassment, it states that it lead to her
No,
death.
you are the state, you are for the petitioner. You concede. Have you considered that it is a case of suicide? You are repeatedly telling that it is suicide. If it is suicide, the state contention is suicide, then where is the question of framing the charge under section 101?
And how can you put it culpable homicide amounting to death?
Your Honor, for culpable homicide amounting to death, there is an intention required. Here, it leads...
No, do the dowry death and this culpable homicide go together? They are different, totally different. Requirement is different, proof is different.
Trial court actually appreciating everything. In a case of where charge is like this, the first question to be answered by the trial court is whether the death is homicide or not. If it's a suicide, where is the question whether the charge will lie? So the first question is whether it is homicide or not. If it is ultimately found that it is homicide, then the question is whether it would amount to murder. Then only the question who is the actual culprit. That is the stage in which things are being done in a trial court. How will you connect these persons? First of all, where is the question of saying that there is a murder?
Your Honor, the council is contesting abetment to suicide in this case. We are not going with the murder, we are going with abetment to suicide, which is dealt under section 108 of ANS of BNS 2023, and we are creating a presumption of abetment to suicide under section 117 ASA 2023. Yes. Presumption of abetment to suicide states when a married woman dies within 7 years of marriage, facing the charges of cruelty and harassment, the court would presume that it is a case of abetment to suicide, Your Honor.
To say that you will have to say, and you will have to estimate there was instigation.
Yes, Your Honor.
Where is it?
Your Honors, the dowry and the dowry, asking of the dowry and the cruelty harassment showed by the family, the husband, shows that they were
Demanding that, does it mean that they were actually instigating her to commit suicide?
And is it the marriage within 7 years as is required?
Yes, Your Honor.
Death is death within 7 years of marriage. It is not there. It is beyond 7 years, isn't it?
Pardon, Your
When
Honor?
they were married?
Your Honor, in 2020.
20.
Yeah.
20 December.
Yes, Your Honor.
15th December.
Yes, Your Honor.
Died on?
And the case is filed in the court in 2024, Your Honors. So it covers the period of 7 years. Yes, Your Honor. Your Honor, by establishing the presumption of abetment to suicide under 117, ASA 2023, we are contesting that it should be a case of abetment to suicide.
Yes.
Mr. Counsel,
So you are giving up the dowry death and culpable homicide amounting to death. You are giving up that petition or alternate.
Alternate, Your Honors.
yeah, Mr. Counsel, you admitted that the charges with which the accused were charged with are section 101, 80. 86 is explanatory section, punitive sections are 101 and 80, only two, right? The accused were tried for the offences 101 and 80.
Yes, Your Honor.
What you are now canvassing is 108A, a abetment to commit suicide. The charge itself is not framed and the accused were not tried with. Can we consider this prayer of yours, can we entertain your argument that if not 101, if not 80, punish them under section 108A? Can we entertain this argument when they were not framed with charges and tried for that offense?
Your Honors, the counsel for the petitioner are going for the alternative charges. We are going for dowry death and abetment to suicide in this case. As the bench,
The answer should be, even if a charge was not framed, under what circumstances a person can be punished for an offense. That particular charge was not framed. Even then, under what circumstances a person can be punished under a particular offense. There are so many judgments on that point.
Problem is that abatement to suicide charge is not framed. So accused has, he could have proved otherwise. He has no opportunity about that provision which is alleged against him.
Your Honor, but the council is filing the case under special leave petition. In special leave petition,
No, in the trial they must have opportunity. The accused also must have opportunity to rebut your evidence. There is no charge about abatement to suicide.
You were about to say that it's a special leave petition.
Yes,
and
Your Honor. Therefore, we are going for the alternative charges, Your Honor. We are going for the dowry death plus abatement to suicide in this case, Your Honor.
So you want the apex court to frame the charge? Yes, thank you. Thank you very much.
If the bench permits, the council would proceed with the prayer.
Please.
Much obliged, Your Honors. It is humbly submitted before this Honorable Supreme Court of Aryavarta that in light of the arguments, cases and authorities cited, the counsel for the petitioner humbly pray before this Honorable Court to adjudge, hold and declare that marriage should be broadened to include de facto and informal unions in dowry harassment cases. Allegations of dowry harassment are maintainable in invalid marriages. To admit dying declaration and pre-schedule video of the deceased, to convict the accused under Section 85, 80 and Section 108 of ANS 2023, that the court declare that the present leave maintainable and or pass any other order, direction or relief that it may deem fit in interest of justice, equity and good conscience. For the act of kindness, the counsel for petitioner shall duty bound forever pray. Much obliged, Your Honor.
How much time? Another 20. Another 20 minutes we will have to carry. Let us see. It's a difficult thing for this one. We know. Okay. Please.
May it please the Honorable Court. For the sake of the brevity of the proceedings, the counsel seeks permission to the Honorable Bench to be addressed as Your Lordships.
Please.
Much obliged. Your Lordships, today I stand before this Honorable Court in the Supreme Court of Aryavarta as a respondent of as a counsel of the respondents, Arjun Mehta, in this matter. The matters between the state of Vindhya and Arjun Mehta and others. Your Lordships, the charges filed against us are Section 80, Section 86 and 101, the BNS. And if Your Lordships are well versed with the facts of the case, I would like to proceed to my arguments.
Please. Arguments.
Your Lordships, before I do, I'd just like to draw your notice to one particular fact, which is the marriage. And this is directly concurrent to the issues I will be dealing with. I am dealing with issue number 1 and 2 One being whether the dowry allegations can be sustainable in an invalid marriage, a void marriage, Your Lordships. And secondly, if the definition of marriage can be broadened to include de facto relationships and live-in relationships. Now, Your Lordships, as we are in the Supreme Court today, we are well aware of the fact that the trial court has had its findings on the facts, and my co-counsel will delve into why exactly they do not amount to dowry harassment. Secondly, we are here to discuss the law because as the learned counsels and the appellants have approached the court under 136, there must be a grave issue of law that is to be decided here. Now, the trial court and high court, Your Lordships, both have ruled in the favor of the respondents in the party, which is Arjun Kumar and his parents. All three have been acquitted on both instances. Now, Your Lordships, the reason I am here today is to discuss purely the stand of law today in the country of Aryavarta. Now, coming to the first issue, the council would like to submit that a marriage is not just a social contract. It is a legal relationship with rights and duties. Without a valid marriage, the law cannot be invoked. Now, according to the Hindu Marriage Act, Your Lordships, as both Arjun Mehta and Nikita Kumar are Hindus, this act governs them. Section 5 gives us certain essentials. The first essential under Section 5 is that neither party has a spouse living at the time of marriage. Now, clearly in this case, Your Lordships, it is undisputed of the fact that the marriage has taken place during the subsistence of the previous marriage. Arjun has contracted the second marriage before divorcing Ruhi, which is the first wife. Now, Your Lordships, if you'd also notice the facts, the first paragraph also clearly indicates, despite knowing that Arjun was married and currently separated from his wife, their bond grew stronger and 2 years later the marriage takes place. Now, Your Lordships, both of them were well aware of the fact that the first marriage is still not finalized and they still contracted the marriage. Now, what am I getting to, Your Lordships, with this? We are getting to purely the stance that this is a void marriage. Now, if Your Lordships are satisfied with that particular contention, I'd like to move on as to why the dowry allegations are not sustainable. Now, yes, Your Lordship.
The law laid down by this court, Seema Agarwal case.
Yes, Your Lordship. So, coming to the case laws, the Reema Agarwal case has ruled in favor of the wife coming
What
from
is
the...
held there?
Yes, Your Lordship. So, they have ruled in favor of the second wife from the invalid marriage and said that it can be sustainable.
What is the gist? Even if the marriage is
invalid,
this law is attracted. This
Yes, Your Lordship.
offense is attracted, isn't it?
Yes, Your Lordship.
So that ground is not available to you.
Definitely available, Your Lordship. If I could provide you this particular judgment, the judgment is Shivcharan Lal Verma and others versus State of Madhya Pradesh. If the court clerk could just pass
Supreme
it on.
Court?
Yes, Your Lordship.
Yes.
Your Lordship, this is a judgment of 2007.
What does it say?
So, Your Lordship, the facts are similar. There is a marriage that is
what is
taking
on
place.
that? Invalid Marriage Act.
It is not sustainable, Your Lordship. Dowry allegations cannot be sustainable in the principles laid down in this particular case. Now, Your Lordship, coming to this particular matter regarding dowry harassment being sustainable in an invalid marriage, we have divergent judgments on this. We have this Reema Agarwal case, we have a Rajinder Singh case, but the position of law in India is clearly clarified by the Supreme Court, Your Lordship, relying on this case. Now, the Shivcharan Lal case has exactly the similar facts, Your Lordship. The second wife, who contracted an invalid marriage, had filed for dowry allegations. And it was deemed non-sustainable. So, this was in favor of the respondents.
In the case which you have cited.
Yes, Your Lordship.
No, the accused was actually, he was charged with two offences, 498A and 306. And 498A, of course, it is found that it is not proved. But at the same time, convicted under 306.
Yes, Your Lordship.
That was affirmed.
Yeah.
That was confirmed by the trial court, which again confirmed by the Supreme Court. Yeah. Then?
Your Lordship, so coming
So how can you say that in this particular case, you got a clean acquittal?
Your Lordship, to support that particular judgment...
If you defended the case, knowing fully that, and you had opportunity to show that there was no instigation to commit suicide. A lady, while living with you, committed suicide. The question, of course, is whether she was your wife or not. That's another point. Now, coming to the next one, a lady whether her marriage was a void marriage or whatever it be, marriage was solemnized. We are not on the legality of the marriage. Thereafter, you started living as husband and wife, going by the evidence. While so, the death occurred. The evidence which they want to brought in to prove the accusation, though the charge were different, the evidence, if it goes to show that you instigated that lady to commit suicide, be wife or not, a lady lived with you, why not another offense would not attract?
Your Lordship, to support my argument in this case, I would rely on a case law, Ramesh Kumar versus State of Chhattisgarh, where it was laid down that the prosecution ought to establish proof for abetment to suicide and based on instigation, both which have not been the case in the trial court or the high court, Your Lordships. We are here today not to discuss if there was dowry or not.
They say that the piece of evidence which was available were totally overlooked by, not appreciated. That is why they said under 136, there is a perversity in appreciation.
Your Lordship, my issues today are contending about the marriage and the invalidity of the dowry allegations.
Take that we are admitting there was, the marriage was void. Even if it was void, the fact is that a lady with whom some solemnization in the nature of marriage, not marriage, nature of marriage, it was conducted. Thereafter, you lived as husband and wife. It is such a lady who committed, whether it is suicide, the question is whether it is a suicide or whether it is homicide amounting to this murder.
Lordship, what exactly is the
Or
question?
whether there was an instigation, abetment to suicide.
Your Lordship, what exactly is the question, Your Lordship, if I may ask you?
If from the evidence which is already on record, and if the 313 examination and the evidence, the oral evidence, everything would show that you had knowledge what was the case which was intended to be proved by the prosecution, and you had opportunity to defend that. You had also defended that and understanding that this is the case. And if there are sufficient evidence, if that evidence which was sufficient were overlooked by the trial court and then by the high court, is it not a case where the Supreme Court should interfere with that?
Your Lordship, definitely only if the evidence was substantial enough. Now, the matter we're dealing with at the hand today, the factual matrix has provided us all the facts. They have provided us with all the statements everybody has given. Now, I wouldn't rely much on the trial court and the high court's decision today as I'm appearing before this esteemed bench. So I will leave it to the good conscience of the esteemed bench to decide. But in this particular case, my co-counsel will deal with in specific detail about the evidences, Your Lordship. I am here to prove directly that the complaint itself is not valid, Your Lordship, because how can you invoke a complaint where a husband and wife are parties to it when there is no husband or wife, Your Lordship? Now coming to, if I may just proceed to my further step. Yes, Your Lordship.
See, when society accepts, you yourself accept that you are husband and wife, why we should not take it for granted? Factum valid, doctrine of factum valid, when things speak about themselves. You have lived for 4 years as husband and wife. Society has treated you as husband and wife. Then why you should not say that you are husband and wife so far as this offense is concerned?
May I answer, Lordship?
Yes.
All right. So,
You heard about no, at the opening when the other side was arguing.
Yes, Your Lordship.
We refer to one decision in 1929 Supreme Court, Privy Council, exactly on this.
So, Your Lordships, in this
There was
particular
no legal marriage.
Yeah. So in this particular case, Your Lordship is exactly right that it is assumed.
And thereafter, that Privy Council later, the Supreme Court had occasion to consider in 2013 another judgment.
So, Your Lordship, you are exactly right in saying that when society has accepted, it must be assumed. But they will assume as husband and wife. Also, the D. Velusamy case from the Supreme Court has also laid down guidelines where they assume that this relationship is akin to marriage. the factors are...
In the nature of marriage.
In the nature
That
of
is-
marriage.
that is the way
Exactly,
in
Your
which,
Lordship. Now, the factors that they have laid down, the guidelines that they've laid down is cohabitation. There was a factor here. Mutual love and relationship, yes. Presenting themselves as society, yes. But also, Your Lordship, in the judgments that I've referred to, I can clarify as to which judgment where it has been noted. It is clearly stated that they will be assumed as husband and wife until the first wife is in this particular scenario. Now, Your Lordship, unless the court is aware that there is a previous wife, there is a previous marriage, they will assume. But in this case, the factual matrix clearly states, Lordship, that the first marriage, before being finalized, before a formal certificate of registration was granted for the second marriage, it has been contracted. Therefore, one cannot assume them as husband and wife when there is a subsisting spouse before this, as there draws certain rights and liabilities that the respondent in our particular matter
Again,
has to
that is
face.
why I said, we are not here to decide on the legality of the marriage or the validity of the marriage. An offense was allegedly committed. What is that offense?
Your Lordship, there is
While
no
living
offense
with
that
you,
has been committed in that touch.
a lady who lived with you as your wife, or after some kind of a function which partakes the character of a marriage, lived with you and then lost her life also. In short, that is the charge.
Does section 85 says that it is valid only in case of valid marriage?
Your Lordship, where exactly?
Section 85.
Are you canvassing the position that
It doesn't say that it must be a valid marriage.
if there
It
was
says
no
husband, that's all.
if there was no valid marriage, then you can do away with the life of a lady?
Your Lordship,
Who is
if I may
living with
answer
you?
that question, there is a contention that the counsel from the respondents would like to put forth today.
No, we are simply putting it in a very
Understood,
single.
understood, Your Lordship.
A lady was living with you, admittedly was living with
Yes,
you.
Your Lordship.
Under a particular circumstances, she lost her life. Merely because there was no valid marriage and it was only a void marriage, can you say that I should be acquitted of no offense would be attracted against me?
Your Lordship, to answer that particular question, I'll draw the points that the appellants are supposed to put towards the court today. Now, let's take into account the Reema Agarwal case. The justices have clearly noted over there that a husband, in this matter, as Your Lordships have stated, cannot hide behind the smokescreen of merely this technicality saying the void marriage or invalid marriage when there is such a grave offense at play.
That's
That is the
exactly what
Reema.
we are saying. You can't take
No, Your Lordships.
shelter under invalid marriage.
Yes, Your Lordships. But then that is the particular issue over here. I'm invalidating the very allegations itself. Secondly, Your Lordships.
Can
it
that
is
be a
again-
license to take away the life of a
Definitely
lady?
not, Your Lordships. It is contended, and I have a statement to make my argument on that. The complainant's claims don't fall on deaf ears, Your Lordships. We share the concern to any woman subjected to harassment. However, the question over here today in this honorable court is whether this invalid marriage affects the legality of the allegations under 498A, which is correspondingly 80 and 86.
You really wanted to say that this is not a dowry death.
Your Lordship, this isn't a matter of legal semantics, but it's about maintaining a balance between protecting the victim and also ensuring that the law is applied fairly. If Your Lordships would permit me to continue with my arguments.
Please, please.
Your Lordships, the further submission I'd like to make is a judgment in 2024 in the court of Chhattisgarh, where a clear clarity was provided as to what the position of law is in India. If the court...
Mohan's case.
Your Lordship, this is a case called Suman Sharma versus State of Chhattisgarh. It is before Justices Sanjay K. Agarwal and Sachin Singh Rajput. If the court clerk may just pass this on. Your Lordship, so as I had mentioned at the beginning of my submissions, there are divergent case laws. But this particular case law has taken into consideration both the Reema Agarwal case and the contrary judgment to Reema Agarwal case in India today is the Rajinder Singh case. Now, what is the issue over here, Your Lordship, is that both these judgments are contrary. Reema Agarwal says that in the invalid marriage, dowry allegations will be sustainable, and the Rajinder Singh case says that won't be. So now this particular judgment clearly states, if Your Lordships may turn to page number 4, I have highlighted the part as to what I want Your Lordships to see. They have mentioned clearly that when there is a conflict in judgments of equal benches of equal strengths of courts, there must be deference given to the earlier judgment. In this case, very clearly stated, the Shivcharan Lal case. And it is also said that the second wife cannot make allegations of 498A and 304 from an invalid marriage, Your Lordship, as it won't be tenable. This is the position of law in the country today. And as Your Lordships, we follow a hierarchical system in India. The Supreme Court's opinion and the Supreme Court's judgment holds precedential authority over every single court, and we are supposed to abide by it.
Yes, I have a question here.
Yes, Your Lordship.
I am interfering. We are about the validity of the marriage. You are making your submission, and probably more lengthier than your submissions, you are interfering and putting questions. It is an addition to that, but still, I am compelled to. Invalid marriage, the issue number 1 speaks about the validity of the marriage, invalid marriage. That points for consideration 1 to be read along with point for consideration 2. Should the law interpret marriage more broadly to include the de facto relationship and informal unions? That is it. Why don't we do that? Why don't we recognize the de facto relationship of you, the accused number 1, with the deceased Nikita, particularly taking the undisputed fact into consideration that it is not just a mere live-in relationship, it was a marriage performed amidst these two, accused and the deceased, in the presence of and with the mutual cooperation of both the families and relatives. They presented themselves before the world that they are the duly married husband and wife and led the marital life continuously for 4 years. Had this incident not been happened, they would have continued till their last breath as husband and wife. Now, because of this incident, you are now taking the protection or a shield that marriage itself is invalid, therefore the question of attraction of section 80 won't arise. That means you were a partisan to the alleged, if it can be called so, invalid marriage. Can you take the benefit of your own guilt to escape from the legal clutches?
Your Lordship, first...
What is the decision of the latest decision of the Supreme Court on a different, of course, not directly connected with this. A marriage was there was no legal marriage in the sense, void marriage, but offsprings were there. Both of the children born in the wedlock. We will not, usually we say born out of the wedlock. Yes. It is not out of, it born in the wedlock. Whether they are entitled to the properties?
Yes, Your Lordship. According to the judgment you're stating, any child born out of an invalid marriage is a legitimate child, and they will have access to the inheritance of the property of both the parents.
Ancestor property?
Yes, Your Lordship, but they won't be a part of the Hindu Mitakshara family.
That is the difficulty. They are not entitled to ancestor property, but the self-acquired property of that person they are entitled to. Is it not the decision?
Yes, Your Lordship.
So, for the purpose of some purposes, though the marriage was not in the eye of law valid, but certain circumstances, for considering the question involved, we can consider that a marriage was there. Here, a grave offense was there, allegedly.
Allegedly, Your Lordship.
That is it, allegedly. The question is, a lady, after undergoing various processes, partaking the character of a marriage, lived with a man, and during living under the same roof, she lost her life. So whether that particular person abetted suicide, though that was not specifically framed from the evidence on record, that is possible. The court should have gone into that question because evidence was available and you were aware of the fact that this is the case of the prosecution and prosecution tried to establish that. And if that point was not at all looked into by the courts below, is it not a matter for the apex court to step in?
If Your Lordships may just let me answer both the questions Your Lordships have posed against me. I will attend to this question first. Now, Your Lordship,
you can leave this question. We put for a larger interest. We put that question.
Yes, sir.
Now, confine your argument and conclude it.
Yes, Your Lordship. So this will be my answer to Your Lordship's question. They have lived as a husband and wife. Now, Your Lordship, if you could please turn into the memorial that we have submitted on page number 19, under the second issue, Your Lordship, which is should the law interpret marriage more broadly, the Council has made the honourable submission to Your Lordships under point number 4, where in the Lokhande case, Your Lordship, the phrase used is husband or relative of the husband in the offence. Now, it states in this case, it is observed by this court that the bare fact that a man and woman live as a husband and wife does not at any rate normally give them the status of husband and wife in law, even though they may hold themselves before society as husband and wife, and the society treats them as husband and wife. This was the holding in the judgment, Your Lordship. And coming to the second question that Your Lordship has posed on what will be the implications if the definition is broadened. For supporting my arguments, Your Lordships, I'd like to submit this particular letter. This document is a letter written by the Ministry of Home Affairs to all the state governments. If the court clerk
Not part of the record.
This is not binding, Your Lordship. This is an observation made and to support.
In a criminal
the
trial, whether this.
Why should we look into it?
Your Lordships, because the issue we are dealing with is whether the marriage should be broadened. I can make the submissions otherwise also, Your Lordships.
See, the government, whatever says, is not binding on the courts. We have to see the validity.
Leave aside all those things.
If Your Lordships might
Such new document which were not part of, never been part of the original records, where is the question of accepting it in a special petition?
As my Lordship had put a question to me, saying what will be the implications, the Council wanted to submit on how the misuse of dowry prohibition acts are being done, which is what the Ministry of Home Affairs is writing to all the
That's
state
a totally
governments.
different thing. We cannot go into that.
All right. If I could make the submissions on the second issue, Your Lordships.
Please.
I will use the essence of this document because it has the Delhi High Court judgment and his obiter dicta 2 in it. So,
Obiter?
Yes, Your Lordship. In the case law
Even if it is the law laid down by the High Court, whether it is a binding on the Supreme
Binding
Court.
on us?
it is not binding, Your
Then
Lordship.
Then where is the question of obiter?
Your Lordship, this is
Where
persuasive.
is the question of
Your Lordship.
looking into the obiter?
This is purely in a
Vice
persuasive
versa, you know that if there is no law laid down, binding decision on a particular point by the Supreme Court, but at the same time there is an obiter dicta in a judgment of the Supreme Court, that of course will be binding to the, and it is having force when it is cited before the High Courts.
Your Lordship,
Not vice versa.
The Council would like to just put it to the knowledge that it was purely for persuasive value.
No,
Now,
you relied upon that Chhattisgarh judgment.
Yes, Your
It's the High Court judgment. Is it binding on us? Whatever is laid down there.
Not
Lordship,
only,
the Supreme
not
Court
only
has
High Court,
clarified.
not only High Court, it's a judgment of a division bench of two judges.
Your Lordships, if I could just continue with this particular point.
So
that
come
was
to the
submitted.
next point, come to the next point.
So it is submitted that there is a concern that broadening the definition of marriage.
You conclude, please. Conclude.
Yes, Your Lordship. It is submitted that there is a concern that broadening the definition of marriage to include informal unions could lead to the abuse of legal provisions. Now, what the Justice has noted in the case of Savitri Devi versus Ramesh Chand, this again, Your Lordships, I'll bring to your notice, is in the Delhi High Court. So it holds no binding value, but is purely for noticing what the situation is, because that is where the cases come from.
Same thing.
The roots.
Same thing, if it is a void marriage, the provisions of penal provisions would not attract. That is a simple law laid down therein.
Yes, Your Lordship.
We got it.
So the submission is that the misuse of it is hitting at the foundation of marriage itself. Now, the learned counsels and the appellants have also spoken about the legislative intent of the acts. These acts were made as a protective measures, not for every single woman, but for women who were wives in legally wedded marriages, which is why we have a wife and a husband, unlike the DV Act, which is protecting women, but they don't have wives written there. They have an aggrieved person written there. They don't have wife or husband. In the DV Act, Your Lordships, is applicable to void marriages, invalid marriages, but nowhere do they mention wife. They talk about the aggrieved person. Now, when it comes to dowry...
Doesn't say wife. Council says husband of a woman. That's all.
Yes, Your Lordship. Over there, aggrieved person also.
The word was used, wife.
Yes, Your Lordship.
Against his wife. Possibly what we can accept.
Possibly. But then they don't, Your Lordship, because they can't extend
You
it.
cited the decision of Uttarakhand.
Yes, Your Lordship.
Whether you have had occasion to go through the judgment of Uttar Pradesh, which was rendered relying on the judgment of, again, Uttarakhand judgment.
Not thoroughly, Your Lordship, but I'm aware of the...
We refer to a judgment of Mohan, starting with Mohan, I am not we had occasion to go through those decisions.
Yes, Your Lordship.
Uttar Pradesh relied on that decision.
But as far as the position of law goes, Your
And consider under what circumstances, though there was no valid marriage, a woman can be said to have the status of a wife.
Your Lordship,
Anyway.
in the present matter, I'd like to reiterate on my stance regarding the binding authority of the Supreme Court. In the Shiv Charan Lal case, we place our reliance. It's a 3-judge bench that has created this judgment, and it is the precedent one. It is the earlier one, contrasting to these divergent judgments. So it holds authority, Your Lordship, which we are humbly relying upon. The final submission I'd like to make, Your Lordship, is that in case it is broadened, this is not related to the case, but it is related to our issue, Your Lordship. In case, what could be the implications? There is a heavy misuse of the dowry provisions, today, Your
Totally
Lordship.
different. We are not concerned
That
with
is my second issue, Your
conclude.
Lordship.
Please conclude.
Yeah. So my final conclusions would be that the present appeal be dismissed and exemplary.
Leave
cause
is to be
Sorry, Your Lordship.
leave is to be declined.
Sir,
That is a short point.
Yes, Your Lordship.
Yes.
My co-counsel will deal with issue number 3 and 4 specifically regarding to what are the
Please,
articles
please.
and specifics.
Your Lordship, I'm the counsel representing the respondents in this case. I'll be dealing with issue 3 and 4 collectively. First things, Your Lordship, with regards to issue 3, before I start off, there have been allegations on us stating that there was no liberty in the marriage, Your Lordship. I would like to bring the fact to this court that the deceased decided to...
Understand that we are not supposed to go into the question whether she was having liberty, she enjoyed liberty, whether there was any violation of Article 21. Totally different. Question is totally different.
Okay,
so you can...
okay, Your Lordship. So it's most humbly submitted...
whether cruelty was there.
No, Your Lordship. I'm getting that.
Don't go into the liberty question. Come to
okay.
that.
Okay, with regards to cruelty, Your Lordship, there have not been any evidences to prove that there is such cruelty, Your Lordship. With regards to issue 3, Your Lordship, which talks about that the demand for the ancestral property be considered for dowry harassment. Your Lordship, there has been a judgment, Baldev Singh, in the Baldev Singh's judgment, the Supreme Court Justices Ajit Pasyant and Arjit Singh Bedi collectively held that demanding per share in the ancestral property will not amount to a dowry demand. In this case, Your Lordship, there is a judgment which says the demand for an ancestral property does not amount to dowry harassment.
Is there any conflicting judgment?
No, Your Lordship.
Are you sure?
Yes, Your Lordship. This is a very recent judgment, Your Lordship.
Demanding ancestral property will not attract this.
Your Lordship, with regards to that, I would also...
No, we are asking a simple question. Are you very sure about it? There is
Yes,
no
Your
conflicting decision?
No, Your Lordship. So far, as far as my knowledge goes, this is the judgment which has been upheld. Even in the Bear Acts, it has been mentioned,
Even
Your
the
Lordship.
interpretation has given so widely that not even a share in the ancestral property, even for a small amount of financial assistance also, in the form of financial assistance, if the wife is coerced or demanded to get it from her parental house, that also amounts to harassment and cruelty.
Again, Your Lordship, in the facts of the case, if you see, it's just alleged. We are not contending. We are not contending that we have demanded any dowry as such.
Yes.
And also, if you are going to the facts of the case, Your Lordship, I want to bring one fact. That is the brother Naveen in this case, particular matter. The brother Naveen is the brother of the deceased, Your Lordship. In this case, went and attacked the accused. The accused one's father, the accused two, had recently had angioplasty, and he's also an heart patient, Your Lordship. So this person had a mens rea to go injure the other person, and that very such person has a mens rea of vengefulness and malified intentions. And that very person has come and given a statement alleging that we have demanded dowry, Your Lordship.
Counsel, they are not on trial.
No, Lordship.
Assault and all this thing, we are not looking into it. Why you mention it?
Your Lordship, this is a statement that is given.
Into that aspect.
Your Lordship, I'm just getting the mens rea aspect as to how the statement has given, Your Lordship. Because the mens rea while giving that statement was to inflict harm upon the respondents, Your Lordship, in this present case. And I would also contend this present suit is filed as a counter suit for the case that was there in front of in the case of assault.
Simply understand one thing.
Yes, Your Lordship.
In a special petition, you must be knowing how to defend it.
Yes, Your Lordship.
If you are asking like this, definitely if this kind of an argument was raised before the Supreme Court will definitely form an opinion that yes, some contentious issues are there. It's a fit matter for granting leave.
Your Lordship, in this present case, the
So,
yes, sir.
confine your argument such a way, there is absolutely no perversity. Normally, concurrent findings, unless the other side is able to establish that there is an utter perversity.
Okay, Your
And
Lordship.
there is no substantial question of law which is to be decided by the Supreme Court involved in the matter. This is not just a concurrent finding not to be interfered with under Article 30,
Yes, Your Lordship.
136.
We would also
That should be
we
the
would
way.
also contend the same, that the trial court, the high court, both are on going through the evidences and arguments placed before them and applying their own legal bent of mind have passed such judgment, Your Lordship. And also, with regards to the Balwant Singh's judgment, Your Lordship, there's this one statement made by Justice Pasyant while delivering the judgment. There must be existence of proximate and live link between the effect of cruelty based on dowry demand and the concerned death. If the alleged incident of cruelty is remote in time and has become stale enough not to disturb the mental equilibrium of women concerned, it would be of no consequence.
That means proximity.
Yes, Your Lordship. In this case, the prosecution has failed to prove there's a nexus between the events that has led to such a demise, Your Lordship. There's no link, there's no evidence, just plain allegations and statements made by the parties, Your Lordship, in this
Counsel,
present
what
case.
is your stand? How your wife died?
Your Lordship, we would contend that according to the facts, she died through an aluminum phosphate poisoning, Your Lordship. And we would contend
How that poison entered her?
the facts are silent on this particular issue, Your
goes
Lordship.
automatically.
But based on whatever we have researched upon this case and whatever the client has told us, we would present this narrative to you, Your Lordship, that recently she lost a major brand deal which made her go to depression. And before that, because of the intoxicated video which went viral, she lost a lot of followers, Your Lordship. And one statistics by Wembley Online Library, it states that people who are in content creation usually face a dark
Now
role.
we will come to a simple question which is not considered or rather argued by the other side.
Yes, Your Lordship.
See, whether it is void or not, the fact is that after a particular function which was conducted, parting the character of a marriage, both of you were lived under the same roof.
Yes, Your Lordship.
At the time of the death occurred in your house.
No, Lordship. The facts are silent on that fact, whether the death happened in my house or in Sri's house or any other place. Facts are very silent on
She
that,
has
Your
come
Lordship.
to visit you.
Your Lordship,
Not you are not going to
it's not
school.
mentioned if it's my place.
No,
if
this
the
is what we are
place-
saying. Shri has come to visit you. That means your house. That is
If it is-
Your
married
Lordship,
house.
Your
Then
Lordship,
you owe an explanation how it happened, how
Okay.
she lost her life.
Okay, Your Lordship. So this is
What is how you discharge the burden? It is not on us. There is a difference between onus and proof.
Yes, Your Lordship. Your Lordship, I would, in that case, point out to the dying
The
statements.
it is not on us, it is your burden. Because the death occurred in your house, she allegedly had a marital relationship with you, she lost her life in your house, in which even you are the only person, or rather the best person to explain how it occurred, the death occurred. Be it a homicide or a suicide, how it occurred.
Your Lordship, to address your question, firstly, I would like to bring in the...
Whether this question was considered by the courts below.
Your Lordship,
And
they're
added
not...
to that, counsel, 1 minute.
Yes, Your Lordship.
Why adverse inference should not be drawn against you?
Okay.
For non-explanation of this fact.
Your Lordship,
How
the...
your wife died. We are not saying whether it is suicide or dowry death. We are not saying. You must say how your wife died.
Okay, Your
Very
Lordship.
ascertained.
I'll answer that, Your Lordship. First things first, the appellants have not charged us on abatement to suicide, and I can't be charged upon something which the charge sheet is completely silent upon, Your Lordship. So the entire case of abatement to suicide doesn't come, and also there is no allegations as such levied upon me. And with regards,
Even if it is not specifically charged,
yes, Your Lordship.
if the evidence led in was sufficient, and at the same time you had the knowledge that this is the way in which the evidence is being led, and you had opportunity, why not the court enter into a conviction under that?
Your Lordship, first can I answer that question first? With regards to how she lost her life, Your Lordship, I would like to first take inference on those 4 dying words that she made. That is Arjun, unhappiness, mistake, and sorry. Your Lordship, I'm telling the sequence of why she died, Your Lordship.
Say, counsel, circumstances.
Yes, Your Lordship.
Within 4 years, within 7 years,
Yes, Your Lordship.
your wife died.
Yes, Your Lordship.
That is not a natural death.
Yes, Your Lordship.
Death by poisoning. The poison was available in your house only.
No, Your Lordship.
Not normally.
Lordship, this is a common. Yes, Your Lordship.
These are the circumstances. She was unhappy. She has expressed in that videograph. She has expressed before her that friend also. So all these circumstances say, even if it is not murder,
Yes, Your Lordship.
even if it's suicide, it is for you to explain
Yes, Your
what
Lordship.
happened to your wife.
Yes, Your Lordship. I would go ahead and explain that, Your Lordship. First thing, with regards to the statements, it's all mere allegations, Your Lordship. And with regards to the circumstances, Your Lordship, our appellants have not gone to the circumstances, like for example, they have not dwelled upon the fact that she lost a very major brand deal, Your Lordship. And again, one more fact that they missed upon is she losing out followers immediately after the intoxicated video went viral. Your Lordship, these 2 cases, it's out in social media, Your Lordship. For example, the intoxicated video is out in the social media itself. Your Lordship, now if you could draw the inferences from those 2 particular instances.
So your contention is that there were the circumstances which prompted her to commit suicide.
Yes, Your Lordship.
You got it.
Yes, Your Lordship. So
Please conclude. Please conclude.
With your permission, can I delve into issue 4, Your Lordship, which talks about the findings of the trial court.
What is it? Finding?
With regards to the findings of the trial court, with regards to the pre-scheduled video and the dying declaration, I'll be combining those 2 in my arguments right now.
Pre-scheduled video.
Yes, Your Lordship. Your Lordship, we would most humbly submit to this court that the trial court and the high court are correct in their findings, because firstly, the 4 words give a room for various interpretations, Your Lordship. The same words, for example, Your Lordship, if I may draw the logic, Arjun, mistake, unhappiness, sorry could also mean, Arjun, what I did was a mistake, and because of which it got us unhappiness and I'm sorry. This is me taking an inference of this particular 4 words and what happened to the party, what happened in the party, Your Lordship. So when there is room for multiple interpretation, such dying declaration cannot be admissible in court of law, Your Lordship.
Anyway, your contention is that they are totally insufficient to
Yes, Your Lordship.
connect you with this offense.
Yes, Your Lordship. That's
And
my
also
contention.
attribute this.
Yes, Your Lordship.
Instigation.
And also,
Yes, thank you.
I would quote a judgment by this honorable court, that is in Adbir versus the government. It was reported that where the dying declaration is suspicious, it should not be acted upon with corroborative evidence, Your Lordship. In this case, nor have they produced the certificate to prove that this is an evidence in this honorable court that the pre-scheduled video should be admissible as a evidence. There's no certificate to prove as such. So, Your Lordship,
Should be, there is no dying declaration at all.
there's no dying declaration at all, is what we are containing.
This piece of a statement cannot have the value of a dying declaration.
Yes, Your
In
Lordship,
the
that's-
eye of law, it is not a dying declaration at
Yes.
all.
Yes, Your
We got
Lordship.
that point.
Yes, Your Lordship. And also dwelling further, this case has brought into this honorable court only on the instance of media trials, Your Lordship.
We need not go into that question.
Okay,
Yes,
Lord.
please conclude in
Okay,
one sentence.
Conclude.
To conclude, Your Lordship, in Amol Singh was the state of Madhya Pradesh, the declaration must be assessed in context of surrounding facts and circumstances. Here the surrounding facts and the circumstances are: 1, she lost a major brand deal; 2,
We
because
got
of-
it. That is
Okay.
why I said.
Okay,
please
Your Lordship. One more judgment, that is Ramesh Kumar was the state of Chhattisgarh that my co-counsel previously mentioned. There's no proof of instigation for the prosecution to establish any abatement as such, Your Lordship. There's no proof that there is cruelty. There's no proof that there's been dowry demand except mere statements, Your Lordship. And we have not even acted upon such a demand, Your Lordship. So with that, I would like to end my argument with Irfan was the state of UP, Your Lordship. This honorable court said that it would be unsafe to record conviction based on a dying declaration alone, and hence has to look out for other evidences, facts and circumstances in order to convict a person, Your Lordship. In this case, there is no other corroborative evidence strong enough to make my...
Thank you. Thank you.
Okay, Lordship. With your permission, may I move it to the prayer, Lordship?
Yes, yes. I have, with the permission of the chair, I have a question.
Yes, Lordship.
Probably it may provoke you to reopen the case, but still, I have a doubt. Admittedly, Nikita, the deceased was residing with you. As at the time of her death, she was in your house. Being her husband and parents, you were only 3 in your house. It is an admitted fact that she died because of poisoning due to aluminum phosphide. It is not in dispute that the aluminum phosphide was being used by you, the accused number 1, 2, and 3, in your food packaging industrial activity.
Yes, Your Lordship.
Therefore, you are the only one who are lastly found in the company of the deceased.
Your Lordship, in this present case...
It is not section 80 alone, section 101 BNS is there. Therefore, burden would be upon your shoulder.
Yes, Your Lordship. So
That
with,
is not at, say, your act she died.
okay. Your Lordship, with that I would like to bring in an example, Your Lordship. Rat poison is present in every other household. This is also...
No, it is not commonly used.
Oh, in every house.
No,
That means
Yeah.
now I did not have any
Don't
house at all.
damage your...
Your Lordship,
Because
what I'm trying
these kind
to...
of things are not being kept in my house.
It's not a common thing.
Aluminum phosphide. Then what are?
To keep the rats away, Your Lordship. So, Your Lordship, my contention was...
You mean to say that aluminum phosphide, cyanide, all these are very essential things which are to be kept in a house?
Your Lordship, what I'm trying to say is the mere possession of that poison that was essential...
So some delicious food is not there, you can taste it?
No, Your Lordship. In food storage unit, there are risks for pesticides to come, Your Lordship. That's the sole reason why, as a precautionary measure, that we have kept such pesticides. Now, with regards to 101, Your Lordship, the prosecution has failed to prove that we have administered such a poison, Your Lordship. There's nowhere mentioned in the facts that I have mixed
That is why
in
we
some
said sufficient. Normally, when in a specially petition, the thing is that unless warranted, don't say anything.
So you must know when to stop.
But here, of course, you are bound to, because we know it's a moot court competition, you will have to. That is why. Otherwise,
Your
we are
Lordship.
saying that generally, in a 136 matter.
Yes.
And now come to the prayer.
Yes. In the light of issues raised, arguments advanced, and authorities cited, the counsel for respondents humbly pray before this honorable court to kindly adjudge and uphold the judgment passed by the honorable trial court and the honorable High Court of India, the present matter. As the decisions are in line with the law and force, facts, and principles of justice in this case, and dismiss the present appeal in its entirety and impose exemplary cost on the petitioners. Thank you, Your Lordships.
See, you can give any rebuttal argument in 2 minutes. And again, we are guaranteeing one thing, we will not be put any question. 2 minutes, conclude it. Because we had put you both sides in trouble, we know. But that was intentional. Why we put that questions, we will study it later.
Your Honor, counsel seeks only 45 seconds to present the rebuttal here. I would like to state that the opposite learned counsel stated the ancestral property is not a demand of dowry, or as stated in the Supreme Court case of Baldev Singh versus State of Maharashtra, but counsel states that this very judgment had stated that ancestral property, in addition to other demands of dowry, shall be considered as demand of dowry. Ancestral property in itself is, of course, as per the definition of dowry and considered as a demand for dowry, Your Honor, as it states any property which is asked must be considered as dowry if it is in relation and consideration to the marriage. Thus, as our opposite learned counsel stated, that Baldev Singh versus State of Punjab stated that ancestral property is not a dowry is false, Your Honor. Much obliged.
Thank you. Anything? 1 minute. They did not. They took only half a minute. Just 1 minute. You can take half a minute. 30 seconds.
Lordships, we'll use less than half a minute, Your Lordships.
If you are taking more time, that means you are also saying that this is a fit case for granting leave.
We'll finish it quickly, Your Lordship. I'll make it brief. Now, there is no assumption over here about ancestral property, as Your Lordships are aware. The facts are very, very clear. It is a mere allegation of Naveen, who is the brother of Nikita Kumar, and the same Naveen is the person who went and assaulted the other family, somebody who had an angioplasty surgery, who was a heart patient. Now, he has just been let out on bail recently. Now, when a person this kind of mental state files a statement saying that his sister was unhappy, ancestral property was demanded, Your Lordship, it is very questionable, and the prosecution has failed to prove it in the trial court or the high court. That would be my only submission, Your Lordships.
So thank you. Thank you very much.
Honorable Sirs, and one of the greatest audiences we have ever witnessed, and there was a spectacular performance from both the parties and the bench comprising of great luminaries. And now I, without much ado, humbly submit to the bench to give response and felicitate the teams who have performed to their utmost ability and knowledge. And I request Honorable Justice Banurmat sir to give response for a few minutes, and followed by Honorable Prabhakar Sastry sir, who has also another function to attend, and sir may be leaving soon after this final round of competition. I request Honorable Justice Banurmat sir to give a response and felicitate the parties.
My brother judge, Honorable Justice Ravi Kumar, Justice Prabhakar Shastri, Professor Mohan, and all the faculty members who are present, and most importantly, my dear student friends who are aspiring to be advocates or future judges or IAS, IPS, whatever field you are going to choose. At the outset, congratulations to all the participants, not only finals, but all the participants in this national moot competition. My hearty congratulations to the organizers, and especially the screening of the facts was first time I have seen. It was excellent idea, Professor. Compliments to that. It always gives me pleasure to address my young student friends. There are few reasons. After completing almost 40 years in the legal field as advocate and as a judge, and after retiring in 2010, whenever I see young students arguing, that is rejuvenating for me also. And it reminds me the days when, as an advocate, I was arguing how the judges were responding, or as a judge, I was hearing the arguments. And present day, it is something uniquely going on. I'm proud to say I'm one of the first 6 moot court mooter, unofficial mooter in India. Why I'm saying it unofficial? Because this moot court competition was introduced by Bar Council in 1981. But when I was in second year of law in 1969, few of us friends thought, why not have this court-like atmosphere and arguments, which we called as mock court, not moot court, but mock court. And 6 of us on the either side, and all the 13 professors were the judges. And we argued the famous case of Golaknath. Just it had come. Why I'm mentioning is this. In those days, we did not have facilities like you have, even to have research, matter to be argued, facts to be argued, etc. How we did? We took out AIR volume, culled out what the argument of the petitioner was there, take out the arguments of the respondents, and based on the finding of the judges, we developed our arguments. In that sense, friends, you are very, very fortunate to have a lot of equipments present today for arguing these moot competitions. You have your laptops, computer system is there, now AI is coming, and I know there are more than 100 sites available, websites are available on preparation of moot courts. I must have attended not less than 150 national and international moots. I was also fortunate to see William Wies competition at Vienna, where my daughter was participating, and so naturally I went there to see how the moot competitions are conducted. This is nothing short of those international moots today we are having. See, what I would like to say, this is simulated court. So your set of arguments are prepared. That is a style you have developed. But this is not what happens in real court. Gavel is put here. You must have the idea what happens in cinema. That's how the court works. Tariq pe tariq. Hero, heroines, antics. No, never happens. The judge asks unconcerned subjects sometimes. questions so that to put you on guard and see how well prepared you are on facts and law. Many times we put odd questions for you. You may be feeling, oh, it is not mentioned in the fact statement. But this is how actually the courts work. The judges ask something maybe even irrelevant, only to see how you are prepared in your arguments. This is what you have to keep it in mind. In my view, it doesn't matter whether you win or lose the competition, because as it is said in Olympics, participation is important. And even if you don't win the prize or come to the finals for the others, see, your participation gives you a lot of experience and then fine. You have not reached the finals, be prepared for the next round. You know now what is wrong with your arguments or your preparations. So best go ahead. Now prepare better, and possibly one or the other day you will be in finals. Maybe you will win the competition. In my view, few tips I would like to give for the preparation of the moods. One is, have total grip on your subject. Facts. Always it is most essential, even if it is not mentioned in fact sheets. You must imagine the situation, how the case is going on, what is the case against us or for us. Then you have to develop. Sometimes we have asked these questions when it is not mentioned in the fact sheet. So you must also have imagination of the entire case, how it should have happened. And then you can give the better reply. Then, of course, court craft. Now, this is one of the things I have recommended to the BCI also, Bar Council also. This is, though it is stimulated, this is not exactly what happens. See, one council arguing on facts, another council arguing on law, and the last prayer, putting your hands. No, this has to be improved. It must be like courts. And for that, my advice is, go to the courts, sit there for some time. Now you are required under the Bar Council rules to attend the courts. But mere going few hours doesn't serve the purpose. Follow a case, during your internship at least. Follow a case and know how the case should be. And now, fortunately, like Karnataka, we are having on website, live Supreme Court also. Important cases are going on live. You are available on YouTube. Watch them regularly. Then you will have idea how the judges ask the question, how the advocates argue their cases. Senior advocates, most of them top-level advocates. So that will give you the preparation and practice to argue the cases. So I'm happy both sides have prepared well and put their best efforts. But ultimately, it's a competition. One side will win, another side will lose. The losers need not feel bad because you have also done your best, but maybe the fact and laws are against you. So thank you very much. It was a wonderful experience for us also to have your arguments. Excellent way of doing it. Thank you very much. Only one thing I just wanted to mention. Those who could not make finals, please remember, there is no success without failure and no winning without losing. Remember it.
We're truly grateful to our esteemed panel of judges for their time, expertise, and invaluable contribution to this competition. I now request Professor Dr. Mohan Rao Bolla, Principal, KRISTU Jayanti College of Law, to give a token of appreciation to Sri Honorable Justice Prabhagar Shastri for accepting our invitation to be a part of the final round of the competition. I now request the gathering to rise as the dignitaries take leave.